Let's turn to our big focus story. The Supreme Court on Friday granted bail to Kerala journalist Siddique Kappan, arrested by the Uttar Pradesh police over his alleged links with the Popular Front of India and other terror outfits. He's been charged under the Unlawful Activities Prevention Act, or UAPA. So a bench presided by Chief Justice of India, UU Lalit, directed that Kappan be produced within 3 days before the trial court, which will release him on bail on conditions that it deems fit. So who is Siddique Kappan? Let's put that out for our viewers. He is a Delhi-based journalist from Kerala. He is also the secretary of the Delhi unit of the Kerala Union of Working Journalists. He reports for a Malayalam news portal, Aji Mukham. He's also a member of the Press Club of India. So that is about who is Siddique Kappan. This is what is there in public domain. However, the case that he is facing in court right now pertains to his links with certain terror outfits. The prosecution has furnished certain material of his transactions with certain banned outfits. What is the case against Siddique Kappan? Let's put that out as well. The case against Siddique Kappan is with regards to his involvement, with regards to his visiting Hathras to cover the alleged gang rape and murder of a Dalit woman. He was arrested when he was on the way to that particular location in Uttar Pradesh. The police alleged that he had links with the Popular Front of India and was going to Hathras to quote-unquote disrupt peace. So what are the charges? There you have it on your screens. Charges against Kappan, section 153A, which relates to promoting enmity between groups, outraging religious feelings, sedition, conspiracy, and of course, Unlawful Activities Prevention Act. What did the Supreme Court say? Now, this is important, viewers. The Supreme Court has made certain terse observations, saying that bail has been granted on the grounds of consideration of length of custody undergone by the appellant and the peculiar facts and circumstances of the case. Let's first listen in to counsel for Siddique Kappan. The advocate in the case spoke to us earlier. Here's what he said.
Siddique Kappan has been in jail for last 2 years. He was arrested on 5th of October 2020. So Supreme Court said that long time in jail is one of the factors for him to grant bail. Secondly, this is a UAPA case. So court has to be prima facie satisfied that there is no truth in the allegations of the prosecution. So one thing about the conspiracy which the prosecution said was that they were carrying pamphlets to create riots in Hathras and other parts. Now, when that pamphlet was read out to the court said that this is just a pamphlet to protest. The right to protest is a part of freedom of speech and expression. There is nothing in this pamphlet which incite riots anywhere.
Let me introduce, joining us here on the program this evening, Namit Saxena, advocate on record from the Supreme Court, Touseef Ahmed, lawyer and political analyst. Welcome, gentlemen. Good to have you with us here on The Big Focus. I want to begin with questions with regards to how the Supreme Court has viewed the matter, and both experts can weigh in on this. Namit Saxena, the Chief Justice of India, says every person has the right to free expression, and therefore here an individual is trying to propagate an idea that there is a victim who requires justice, and therefore let us raise a common voice. What is wrong in that? Is something like that a crime in the eyes of law? So clearly the court not convinced Mr. Saxena of any malified intent.
See, the basis of the order of the Supreme Court today granting bail to the accused is not freedom of expression. The basis is that charge sheet has been filed, one. Charges have not yet been framed, is second. Third is the length of custody. So considering this, that even otherwise if UAPA is alleged against the accused, considering that even charges have not yet been framed, only charge sheet has been filed. The trial court is yet to frame charges against the accused. He has been in custody for two odd years. Considering this, the Supreme Court said, okay, you have to release him on bail. But they've put very strict conditions upon him, that he has to be in Delhi for 6 weeks, etc. And he has to mark his presence in the concerned police station. That all is there, but the condition, the basis for the bail today is not freedom of expression. The basis of it is the length of.
No, I was quoting what the CJI said, sir, because the CJI, and I was actually quoting it verbatim. This is what was mentioned. Yes,
that is an observation. That is an observation made during the course of the hearing, but that is not the basis of
Not the basis for bail. Yes, point taken.
Yes. So that this is what the Supreme Court has held today.
Yes, absolutely. But, would you concede that given this observation, as you rightly corrected, can we say that the prosecution has perhaps in some way failed to furnish, it's not an acquittal, it's just it's a bail that we are looking at. But given the observation, like we said, has the prosecution failed to furnish material that could fix culpability, Mr. Saxena?
No, so at this stage, culpability is not even to be fixed. That is what the Supreme Court observed, that even charges are yet to be framed. See, after, hearing the accused on whether he has to be discharged or not, the trial court may say there is no 153A, or the trial court may say there is no UAPA, or the trial court may say sedition, of course, is an abeyance right now. But all these charges, that is at the stage of framing charges against the accused. Right now, the Supreme Court hearing a bail petition cannot determine culpability at all. That is what the Supreme Court has rightly done.
Yes, but the reason we are discussing this, Mr. Namit Saxena, is because of the observations, because of the arguments presented, the submissions made, and the court's observation. It becomes very important to understand it in the current context, where time and again the top court has upheld the point about bail being the norm, jail being the exception, but yet we see prolonged period of under trials, languishing in jail without charge sheet. In many cases, like you said, charges were not framed. UP government, it seems, at least in this stage, in this case, couldn't satisfy the Supreme Court to continue with Kappan's jail time. To that extent, are you convinced, Touseef Ahmed?
So you see, before coming to Supreme Court, Kappan had gone to the High Court, and the Allahabad High Court had rejected his bail. What was the observation? The observation was that incriminating material was found against Kappan, for which reason the bail was denied. So, considering that, the court specifically asked the counsel of Mr. Jethmalani, who was representing the Uttar Pradesh, the state of Uttar Pradesh, that what materials you have found, and what are their answer? It is laughable. One is ID card and some literature. Then the court asks, any explosive found? According to you, literature was found in his custody. Then there's a clarification, no, literature was in the car. What is that literature? That refers to, Save Black Life Matters, which was the, which relates to the US, if you will recall, a few years ago, there was a huge uproar when a black man was shot by the police officer, and then there was a huge uproar in the society that Black Lives Matter that was going on, which was referred to by the State Council as toolkit. Toolkit, what for? The toolkit that Kappan was using to do a rioting in Uttar Pradesh, and that he was funded. That is also an allegation. With 45,000 rupees, this is the allegation. Nothing has been proven. That 45,000 rupees funding was given to Kappan to come to Uttar Pradesh and do rioting. Is this laughable or not? Supreme Court asked various questions.
Like Mr. Saxena said, the bail was not granted on the basis of all of this or on the submissions made. In fact, the court has clarified this in the order, saying that it has refrained from dealing with or commenting on the progress and material collected by prosecution, as the matter is at the framing of charges stage. So, let's keep that separate. I mean, I understand the point that you're making.
Practice.
The kind of exchange and proceedings that happened in court. Go ahead. Please finish.
It's a general practice. Supreme Court obviously will not go into such details and will not have time to consider all the materials and go into evidence, because this is not the stage we have, which requires all of that. In a simple way, we can say that High Court rejected the bail, saying incriminating materials were found, and Supreme Court in his wisdom thought that no, it is not correct. This man deserves to be out on bail, and Supreme Court did observe that, every person has right to free expression. He is trying to show that victim needs justice with regard to Hathras rape, and raise a common voice. Is that a crime in the eye of law? This was asked by the Chief Justice, and then his brother judge asked. Similar protests were in 2012 at India Gate, which led to a change of law. Till now, you have not shown anything provocative. So the court was not satisfied from the state, from the UP Council, that they have not given anything provocative which will convince the court from rejecting the bail. So this was a fit case for bail.
Right. Namit Saxena, that is the issue, that we want to address, that is there an element of misuse that that the court also is kind of harping on, that will the charges of UAPA really stick? Given the fact that to the questions of the court on what incriminating material was found, the prosecution did not really have anything substantial. Therefore, it leads us to ask that are the governments of the day misusing these draconian laws time and again against select individuals?
See, against, misuse of certain laws or not, see, it is very difficult in this particular case to comment on it right now. Because see, the accused is yet to face the trial. The burden, although the burden is on the prosecution to discharge, a duty that there is some material found against him, all right. But this does not mean that, he has been acquitted of the charges. He is yet to face the trial. Evidence will be put. See, at this stage of bail, the prosecution is under no obligation to put all the incriminating material to the accused in form of a reply to the bail application. So, the material which is shown to the court can be restricted to the manner that, that this accused should not be released on bail at this particular point of time, is one. Second, if you'll see the order today...
So you are saying the prosecution has withheld certain incriminating material? It is not fair to assume that everything was submitted in order to argue for an extension of jail period? Okay.
Yes, we don't know because charge sheet has already been filed. Whatever material the investigating agencies have collected, that is all there in the charge sheet. On the basis of the charge sheet which has been filed, there can be supplementary charge sheets also, we don't know. But on the basis of the charge sheet which has been filed, charges will have to be put to the accused that whether the court can charge the accused on these particular charges or not. That is a subject matter of the trial court. The Supreme Court cannot enter it in, the domain of the trial court is one. Second, if you'll see that the order today, observes that, the accused is also put under PMLA. And therefore, Mr. Sybil appearing for the accused sought liberty that, that he has to apply, for bail in the PMLA offences also. So this does not mean today that I'm not sure if, custody has been taken of Sidiqque Kappan under PMLA yet or not. But he may be taken into custody under the PMLA offences also. So this does not mean that this is a complete win-win situation for the accused. The accused is yet to face the rigors of the trial.
Yes.
So, it is not proper to assume that, just because he has been granted bail by the top court means that he is, out of the box.
But isn't the timing suspect? Okay, I would allow Mr. Ahmed to come in. You were wanting to make a point. Go ahead, Touseef Ahmed.
I was saying that, it is the most lame excuse to say that, oh, I have the incriminating material, but court is asking me to show the incriminating material. I am not bound to present it to the Supreme Court, and I will not present it to the Supreme Court. I will produce those incriminating material in the trial court. This is the lamest of excuse because my friend is defending the indefensible. This is a fit case of misuse of the power and abuse of the power, and therefore he has nothing else to say. So then he's saying this. Let me just point out one more fact. The court asked the counsel for the Uttar Pradesh told before the court that they are in the process of getting an approval. And then the Chief Justice of India remarked that if an attempt to make somebody approval was going on, then it means that the matter was not ripe for trial. It means that you have no material. You're looking for an approval to somehow get this accused convicted in the case. You do not have any material. And please let me also make this very clear that if the court asks for material and the counsel says that if assuming his my friend's argument that I do have the material and I have not presented, then the court will assume that you don't have the material, because that's not how the court functions.
Got your point. Yes.
That's not how the court functions. It's a lame excuse that he's putting forward.
Mr. Saxena, I have another question. In the case of Teesta Setalwar, the Supreme Court said that she's not a terror accused. She's not booked under UAPA. Why have you kept her in jail? Which means that when it comes to charges of UAPA, the court would be more cautious in granting bail. Yet, even soon after that case, when this case comes up, Mr. Kappan gets bail. So that leads us to believe that surely the prosecution did not have a watertight case. Not at this stage, at least.
See, Teesta Setalwad's case stands on a completely different footing. The reason why Teesta Setalwad was granted bail was because the High Court, while issuing notice and calling for the status report from the prosecution, gave a date of 6 weeks where a particular accused is in judicial custody. So, what weighed upon the Supreme Court was that during this period of 6 weeks, you can't keep her inside. So, we are granting.
No, that I understand.
Bail.
But the court had referred to the UAPA and said that she's not booked under any of these stringent sections. Which means that when somebody is indeed booked under these sections, bail is difficult. The court does not show laxity in granting bail. But it has granted bail, which is why I asked you the question on whether prosecution's case was weak. Yes, go ahead.
No, see what happens in UAPA is there is this particular section 43D clause 5. Which shifts the onus that the trial court has to record, the court granting bail has to record that there are reasonable grounds of believing that the accused has not done it or the accused will not repeat the same offense in future, which is the degree of satisfaction in such cases goes very high up. That is why bail becomes very difficult in UAPA is one. Yes. Second, what weighed today before the Supreme Court is that the period of custody. See, this particular accused has been in custody since 2 long years, around 2 years. Even charges have not yet been framed against him, or the charge sheet has been filed. So considering this, because trial in criminal trial commences.
The charges are not filed because you do not have enough substance to file charges.
Multiple reasons. It can be due to multiple reasons. See, first, cognizance is to be taken. For that, summoning is to be done. There can be supplementary charge sheet. There can be a variety of reasons for charges not being framed. The accused may not be cooperating. As for example, my learned friend also pointed out, although I don't know, I'm not commenting on his, observations of criminal law, but approver can be at any stage. So saying that, that we are, getting an approver can be at any stage of, matter, irrespective of whether charges have been framed or not. So that is, keeping that apart. Considering this, the charges have not yet been framed, the Supreme Court deemed it fit that at this stage, the accused should not be incarcerated. Let him come out. We'll put very strict conditions on him so that he, presents himself during the trial. And, the trial will take its own course because trial is not going to be over in a day or two.
But, prima facie, on the face of it, what do we see? We see here is a journalist who was on his way to cover a rather gruesome case of gang rape in Hathras. He was stopped in his ranks. The police, and we're showing those pictures as well on the manner in which he was arrested. The procedure also, of course, according to many, were not followed. The proper procedure of arrest not followed. He was stopped on his way to Hathras, arrested there and then, of course, the UP government said that there were incriminating documents found with him. He was going to create communal disharmony. That was the prima facie case that the prosecution had, which it seems the court has not been convinced about. Other thing is, he's a journalist. So clearly the court has taken note of the fact, even though the UP police had said that he's not a journalist, he's just posing as one. Quick last comment, Touseef Ahmed.
You see, we cannot forget the fact that the crime in question, Hathras rape, was the worst of its kind. And we saw that the body was burned. In other way, we can say that the evidence was, erased without informing the family members or without having them in their absence. The body was burned. Now, the question is that in this situation, any modern society, any modern democratic society would expect that there will be a public outrage, like there was a public outrage in Delhi in 2012 that the Supreme Court judge referred to. And unless there are these awakening, unless there are these uproar against this kind of dastardly crime, there cannot be reform in the society. Yes. There was widespread protest in 2012, which resulted in a new law being passed by the parliament. Similarly, in this case, we had a Dalit girl being brutalized, and even after her death, were being denied justice. Therefore, if there was any uproar, if there was a widespread protest, it could have resulted in a favorable law. Yes, but there is a distinction between protest
and maintaining law and order coming under the state government. Well, there are arguments on both sides, as we can see. Namit Saxena, Touseef Ahmed, thank you so much for joining us with your informed opinion, and thanks for also throwing so much light into the important aspects of this case. Well, with that, let's take a short break. News and updates continue on the other side. Stay with us.